If you look at Evidence Act, you say hearsay evidence is not admissible. Supposing I am a blind litigant and I want to prove a document. I am the author of that document, I have signed it. And when I appear, and this is a real case that I am talking about. And it was a case about when I started my practice way back in the year 84-85. I started in 82. It was a real case of two brothers who were blind. And the third brother who executed a will in favor of two brothers who were blind. Third brother was also blind. And it was a probate case. The first question that the Honorable Judge asked me, how can I allow this will to be proved? Because one of the attesting witnesses was also blind. I told that you will have to allow this attesting witness to have the document read, and if he confirms that yes, this is the contents of the document which I signed as an attesting witness, you should accept that testimony. But initially, a particular judge did not agree. But good luck for them that sometimes later, when the other judge came in the same court and the matter was placed before him, he accepted this. That's how I could succeed in getting the probate done. Now, how this constitutional attitude or manifestation of policy and law in the Constitution changed. In 1980, there was a systematic movement organized demanding a legislation on the rights of persons with disabilities. And it was on 16th March 1980, to be precise, that a demonstration was led by me was being taken to the house of the Prime Minister, the then Prime Minister, Mrs. Gandhi, which was stopped, lathi charged, and there was an international fury against that lathi charge. And Parliament was robbed. It was at that time that the then Prime Minister assured and agreed in principle that a law on the rights of persons with disabilities has to be brought in. But that did not, and thereafter 3 committees, successive committees were formed for suggesting a draft of legislation. One was Laladwani Committee, the other was Ramadevi Committee, and the third one was Justice Behrool Islam Committee. The last was Justice Behrool Islam Committee, which gave its report in 1989. But still it took a lot of time, and ultimately we got the first legislation on the rights of persons with disabilities in 1995. But prior to legislation also, as I said, that in the fundamental right, disability was not a qualitative ground, and therefore there was a suspicion as to whether persons with disabilities enjoy the same fundamental rights. Are they included in this chapter or not? Or it is only the social security which they are entitled to? But in 1993, when this Mandal Commission was being implemented and OBC reservation was in question before the Honorable Apex Court, we also intervened. My organization intervened. And we had to intervene because 3% reservation was made available in jobs to persons with disabilities in groups D jobs, C and D jobs, lower rungs of the employment opportunities. But that 3% was in addition to reservation in favor of different castes and other backward classes. What the government of the day did at that time, that they merged this reservation in caste reservation, meaning thereby that open category disabled would not be entitled to any reservation. And the SC, ST, OBC disabled will get the reservation on the basis of their caste and not on the basis of their disability. And this was done to avoid that ceiling of 50%. Because when they implemented 27.5%, the total reservation came to 49.5%. We intervened. And the first judicial pronouncement, and I would like to say here that Indian judiciary has been very positive, more positive than any other judiciary including US, on the rights of persons with disabilities. And then in this case, Supreme Court declared that reservation for persons with disabilities is horizontal and not vertical, cuts across caste lines. And it is a reservation relatable to Article 16(1) of the Constitution and not under Article 16(4). Because inherent in the fundamental right of equality is the right of special and differential treatment in favor of persons with disabilities to make them equal with others. And this declaration probably was the first such historic declaration that opened the doors for us to advocate for the grant and protection of all fundamental rights and statutory rights on equal basis with others. And we must remember that this declaration was pre-legislation on the rights of persons with disabilities. And at the same time, there was another Supreme Court pronouncement on our petition. The persons with disabilities were not allowed even to compete in civil service examinations. And therefore we challenged. And it was because of a rule. There was no explicit prohibition, but there was a rule which said that one has to write the exam in his own hand. And since blind or a person who is who doesn't have the hands is not able to write in his own hand, he was disqualified. We challenged this and we asked two things. We said that there should be a declaration that persons with disabilities are entitled, including blind, are entitled to compete in civil service examinations and hold the post if they are selected. And we got this judgment. That was another historic judgment, which again opened the discussion, or rather settled the position that we are entitled to the fundamental rights. Then came 1995 Act. And 1995 Act, though was very weak, but we accepted it because we thought that at least in the legislative horizon in the country, let us have some law on the rights. But again, thanks to the judiciary, while interpreting these laws, the provisions of this law, our high courts and honorable apex court had been very proactive and positive in favor of persons with disabilities. You would be surprised to know that the statutory provision for reservation in jobs was not implemented for about 17 years. The Act came into force in 1996. We started judicial activism against non-implementation of this statutory provision.